Thank you, Honorable Vice Chancellor, sir. Thank you, ma'am, distinguished panelists, ladies and gentlemen. It's a pleasure to connect with you electronically via Zoom for this meeting. Today, we talk about a very important topic, which is pertaining to cybercrime investigations in India and the challenges, particularly given the cyber legal frameworks. I have a small presentation. Let's begin with the presentation. Cyber crime investigations and legal issues. It looks to be a topic that's more got to do with detectives, with the law enforcement agencies, with police, and of course, the cat and mouse game between the law enforcement agencies and the police. But a cyber crime is a complex, holistic phenomenon. And you have to specifically keep in mind a variety of legal aspects when you look at cybercrime investigations. Today, cybercrime is everywhere. There's hardly any place when you can say that there is no cybercrime. Why? Because the electronic format has become the most predominant methodology today. And everybody is now all out to make quick buck, including the cyber criminals. Today, cyber criminals have realized that the coming of COVID-19 has been a massive boon to them. Why? Because during this time, cybercrime has massively propagated and has basically gone ahead from strength to strength. Cyber criminals have been ruling the roost during COVID-19 times. And we have seen some massive increase in cyber crimes. In fact, I can clearly say that the golden age of cybercrime has actually begun with the coming of COVID-19. It's not that cybercrime was not with us all these years. Cybercrime has been with us for the last more than 50 years, ever since the internet came into existence. But cybercrime was growing with each passing year. However, the coming of COVID-19 was a different ballgame that humanity had not planned for. And COVID-19 effectively acted as a catalyst, as a steroid into the whole ecosystem. So consequently, cybercrimes, the way they have actually grown, their manifestations, their avatars have been so phenomenal during COVID-19. And the impact of these cybercrimes has been so remarkable that the economic impact continues to astonish persons. Well, as of the end of 2020, the world had lost more than $6 trillion thanks to cybercrime. Come 2021 end, by the end of this December 21, the world is expected to lose more than $8 trillion across thanks to cybercrime. And therefore, the rapid increase in cybercrime today is an essential element that every jurisdiction has to brace themselves at. So in this particular case, we saw the fraudsters posting as SBI telecallers, and they're duping thousands of people, and 200 cases already filed against this gang. Now, this is happening across. You're getting all kinds of calls. Most of the time, people tend to believe those calls and quickly become victims of cybercrime. The other day, my teacher who had taught me in school called me to say that he had got a call from his bank who wanted just to revalidate his account and therefore asked for his credentials, and he gave them. And within 2 minutes, 80,000 rupees were deducted from his account. We filed an FIR, but that money was dead and gone. Nothing much has happened there. And this is now the plight of a majority of these financial fraud cybercrimes that we have begun to start emerging. So therefore, the thumb rule is, from a user standpoint, be very careful, because cybercrime is no longer just a European phenomenon or a Western phenomenon. Today, it's become a very intrinsic and a customized Indian phenomenon. Imagine you getting an email saying that the RBI or the Reserve Bank of India has decided to give you a prize of 50 lakh rupees. and therefore please pay us some amount, 2,000 rupees for processing fee and give us the credentials. Now, a majority of the Indians lap onto this fantastic and too to be true offer, and would end up giving their credentials only to find that they become victims of cyber crimes. Globally, cybercrime has been massively increasing. We've seen Interpol arrests 1,000 suspects, and they have seized about 27 million in a crackdown on cybercrime recently. And these are very, very small figures. When I look at just seizure of 27 million as compared to 6 trillion globally, then you quickly find out that while efforts are being done by law enforcement agencies to fight the menace of cybercrime, the said efforts are not too exhaustive or too comprehensive. And that's where the problem starts arising. Different surveys tell us different stories. As per this survey, 59% Indians were victims of cyber crimes in a couple of months. And this, I think, is not telling you the true picture. The reality is that today, out of 100 Indians, about almost 90 to 95% of Indians have become some victim of some cybercrime, whatever you would want to call them. And these alarming signals are growing at a very, very fast pace. In India, we had a small place called Jamtara, a small region. They were pioneers in their space. What did they do? They decided very quickly and very early that we must adopt cybercrime as an economic model, the entire region. So everybody in that small area turned on to cybercrime and started generating huge volumes of money. And then Jamtara effectively became a fortress because it was reported that it was not possible for the law enforcement agencies to get inside Jamtara. And you thought there's only one Jamtara, come COVID-19, and we have begun to see the cottage industrialization of cybercrime in India. The Jamtara model has been mushrooming in different parts of the country, in different cities, in different smaller rural areas, semi-urban areas. And logically so, people have lost their jobs, people have lost business opportunities, monies during COVID-19. And in this pale of darkness and pain, suddenly cybercrime appears to be the knight of shining armor who would come and who promises to give you a lot of money. And therefore, most of the people are not even bothered whether cybercrime commission is an offense or not. They are increasingly getting attracted to this entire phenomenon of engaging in cybercrimes. No wonder our Indian figures are not at all accurate. If you look at the figures of the National Crime Records Bureau, you'll quickly realize these are very, very paltry figures. A couple of thousand cybercrimes in 1 year. You'll ask yourself, how is that possible? But then you go deep and find out those are figures of only the registered FIRs. And this is only possible because in our country, underreporting is the de facto norm of the day. This is continuing for the last 2 decades, and even now it still continues. Because in India, people believe that if you report a cybercrime, your social reputation, goodwill, standing could be impacted. People could see you in a negative light. There could be a scar on your reputation. And therefore, people want to suffer in silence, and not report any kind of cybercrime activities. But were people in India prepared for the golden age of cybercrime? I don't think so. People thought cybercrime is going to be here, but will be manageable and things will be fine. But look at the huge quantum of cybercrime growth during COVID-19. And you quickly start realizing that this is now a new era. And you have to be now prepared for this new era. No longer can you say that cybercrimes is a Western phenomenon or that we are absolutely fine and hunky-dory. No, cybercrime has now started knocking your doors, whether you are in a city, whether you are in a rural area, or whether you are in a village. Therefore, the entire issue of cybercrime investigation itself assumes much more significance during the golden age of cybercrime. This golden age of cybercrime has only begun. It's not over. It's going to be with us for the next many decades. And therefore, all stakeholders in the digital ecosystem have to now make up fresh strategies and approaches on how they can deal with this growing menace of cybercrimes. Good news, a lot of work is being done in different sectors. We've actually seen various guidelines on cybercrimes by apex regulators. For example, University Grants Commission has also issued its own set of guidelines so as to fight the menace of cybercrime. But then, before we even begin to the concept of how we go about examining a cybercrime investigation, the fundamental question is, what exactly is cybercrime? Well, that is a particular term that's constantly being evolving and expanding in its scope, applicability, and approach. Initially, the term cybercrime only referred to criminal activities done in cyberspace. And then you thought that is enough. But very quickly, scholars across the world realized that cybercrimes are not just done only in cyberspace. They're also done in the physical world using cyberspace. So typically, you could either have cybercrimes which are targeting cyberspace or cybercrimes which are doing criminal activities but using cyberspace as a medium or methodology for committing various cybercrimes. So in this entire ecosystem, cybercrime is a constantly evolving paradigm. Cybercrime is a generic word that's basically referring to each and every criminal activity that's either done in cyberspace or that's done using cyberspace or computers, computer systems, computer networks, computer resources, communication devices, as also data and information in the electronic form. So in a nutshell, if you do a normal crime using the digital medium, you automatically commit a cybercrime. You do any crime targeted at a computer platform or an internet portal or data that's being transmitted or disseminated using internet, you commit a cybercrime. So this ambit of cybercrime is continuing to grow on with each passing day. When I look at the dictionary meaning, the Merriam-Webster dictionary says that cybercrime is criminal activity such as fraud, theft, or distribution of child pornography committed using a computer, specially to illegally access, transmit, or manipulate data. So cybercrime today ranges across all kinds of activities and endeavors. And you begin to start realizing that cybercrime is happening in banking sector, it's happening at individuals level, it's happening at the level of companies, corporates, and even nation states. So much so, remember a couple of months back, we had the attack on the Mumbai grid in 2020. And the entire electricity grid went off for a couple of hours. People thought it was a normal electricity failure. But when you went to the darknet and started hearing the whispers on the corridors of hackers, you quickly realized that here was a cyber attack that was targeted against the particular grid. That's what is information available in the public domain. So very quickly, at one end, there are crimes that involve fundamental breaches of personal and corporate privacy, such as assaults on the integrity of information held in data depositories, and also the use of illegally obtained digital information to blackmail a firm or an individual. On the other hand, there are other crimes which are specifically attempting to disrupt the actual working of the internet. In fact, broadly speaking, when you look at the entire gamut of cybercrimes can be divided into three broad categories. The first category is cybercrimes against persons, where the criminal activity is targeted against a particular person. So whether it's cyberbullying, cyber trolling, cyber harassment, cyber nuisance, these are all categories and illustrations of cybercrimes against persons. The second category of cybercrimes is cybercrimes against property, where the target of the criminal activity is a particular property. It could be data, it could be information in the electronic form, it could be servers, So hacking and cracking are classical examples of cybercrimes against property. The third category is cybercrimes against nations, where the criminal activity is targeted against nations. For example, cyber war, cyber terrorism, cyber radicalization are increasing instances of cybercrimes against nations. Well, earlier, it was just one particular broad amorphous area called cybercrime. Then came mobile crimes, then came social media crimes, now come artificial intelligence crimes. And you realize that while the ambit, nature, and character of cybercrimes is constantly growing, the cybercrimes could still broadly be classified into the three buckets of cybercrimes against property, cybercrimes against persons, and cybercrimes against nations. Though some scholars believe that social media cybercrimes are a distinctive fourth category, and therefore, while they can be included in the other three categories, they also need to be given their own distinctive significance. And social media has suddenly become a kind of no man's land. Why? Because people believe that they are anonymous, and people believe that they can actually write anything on social media and get away with it, without realizing that everything on social media is getting documented somewhere, without realizing that law enforcement agencies are in constant touch with social media platforms, and without even realizing that social media platforms are now increasingly sharing their logs and identity details to the law enforcement agencies, of course, on receipt of appropriate lawful requests. Social media is a completely new paradigm, and investigating cybercrime on social media brings in far more distinctive new challenges. Why? This is because of the growing and constantly evolving nature of social media. In India, we've seen various revolutions after independence. We saw the Green Revolution, then we saw the White Revolution or the Milk Revolution. And now, since the last 1 decade, India has been seeing yet another new revolution. I call it the Great Indian Vomiting Revolution, where Indians are vomiting information about their personal, professional, social lives on the internet, on social media, without understanding the legal ramifications of the same. So when you are going to vomit everything online, obviously there are people who will going to be studiously scrutinizing your data vomit, and on that basis pick up stuff and then go and attack you. Let me give you an example. There's a recent case where one of our clients, they were a young couple in the telecom side, both tech savvy. Both decided after the second wave of infections was slightly slowing down to take a break and go to Manali. And they put it on social media saying that they were planning to go to Manali and that people should give them suggestions of what they should eat, what they should see, what they should buy. And each of the days when they were in Manali, they were constantly posting their photographs. We have now come to this Rohtang Pass, we've done this shopping, stuff like that. And all these, both the husband and wife were actually uploading these photographs from their own smartphones onto the internet directly. When they returned back after a week, 10 days back to their home, they were in for a shock. This is so because the entire house of theirs had been burgled and there was nothing left in the house. The burglars had actually taken everything. Why? Because these burglars were also watching them and following them on social media. And because these people were posting those pictures on social media from smartphones without even sanitizing them, these pictures had the relevant metadata, including the latitude and longitude of their location. So that was an absolute final confirmation to the cyber criminals that these guys are actually in Manali and they're not going to come back soon. So they had ample time to go ahead and ransack the entire house and just go away with almost anything that they could find. So we also began to start seeing new social media cyber crimes like cyber trolling, cyber stalking, cyber bullying, cyber harassment, cyber targeting. In fact, you would be surprised to know that in the Indian educational ecosystem, cyberbullying has become the #1 cybercrime and a matter of immense concern for all the stakeholders. Well, recently we saw this case. This was the case of an educational institution which suddenly saw that some online entity started bullying the teachers and the principals by every day coming with a new disclosure. This disclosure was pertaining to the personal lives of the principal and some of the teachers. And each day there was so much of masala and so much of spice in every day's disclosure as old skeletons in the cupboard were being taken out. So somebody was having an affair with somebody else and the gory details of the affair. These were all mechanisms that were aimed to target the principal and certain members of the staff so that they can be bullied, they can be harassed, they can potentially be trolled. And of course, their reputation can be sullied. The institution decided to take action, and we were able to identify the source and the concerned person who was doing it. But because the concerned person that was doing it was also a student of the institution decided not to take much action. So the problem is, in our country, cybercrime is happening everywhere. But the people tend to close their eyes. It's like water everywhere, not a drop to drink. I've slightly modified that particular saying to say, cybercrime everywhere, not a place to go. And that's now the new ground reality. Wherever you want to go, whether it's the Himalayas, whether it's the Kanyakumaris, whether it's the Deccan Plateau, whether it's the cities or the towns or the villages of India, you find that cybercrime is now your constant companion. And all kinds of challenges are now being posed by cybercrimes onto us. There's loss of data. You'll end up losing data. And data today is your new oil of the new data economy. You lose your data and you find yourself so helpless. The other day, a friend of mine suddenly was having an iPhone, suddenly discovered to his shock that his iPhone just went dead. And he was so careless that he had not even taken the backup of the contacts. And today, everything went along with the iPhone, including all contacts. So a cybercrime today leads to a classical loss of data. It also potentially could lead to loss of location. There are challenges, of course, associated with national legal frameworks. Are the legal frameworks alone sufficient for cybercrime regulation, or are they deficient? Then what are the obstacles in the detection, investigation, and prosecution of cybercrimes? That itself becomes a big challenge, because today, investigating a cybercrime is a huge task. Unlike physical world crime, which is far more easier to tackle, cybercrime is far more complex. So Mr. A had a road rage with Mr. B, and in this road rage, took out his pistol and shot Mr. B. Mr. B died. The police registered a case of murder, investigated, looked at the various testimonies of passers-by, were able to identify this gentleman, picked him up, and now he's facing trial. That's simple, right? Imagine the same scenario, but done in cyberspace. Instead of road rage, it's cyber rage. A person is sitting online, he is frustrated, he's angry, and he decides to target his boss or his colleague who has not spoken to him very kindly, and then decides to come up with an anonymous handle, and using the anonymous handle, posts all kinds of obscene, defamatory, derogatory content against the boss or the other colleague. And because this particular person is hiding behind the cloak of anonymity, he or she thinks that he can't be getting caught. Today's cyber criminals are getting far, far more intelligent. They're using tools like virtual private networks, which actually allow you to mask and hide your exact location of your server. So consequently, it becomes even more difficult for the law enforcement agencies to come and track you. And in case if you're using a virtual private network of a foreign service provider, then for the Indian law enforcement agencies to get the details of your logs and your access and your illegal activities from a foreign VPN service provider, it's like well nigh impossible. And most of the time, such kind of logs are not yet received. And consequently, cybercrime matters just tend to hit a dead end, and often nothing happens there. And this also primarily happens because a lot of data pertaining to cybercrimes is located on servers which are physically outside the territorial boundaries of India. So those are located in countries like America, like Europe, where Indian law does not apply. And therefore, trying to get those people back to India is such a huge challenge. First of all, trying to identify who are these people who have done these cyber crimes is a big challenge. Number two, trying to request the service provider located in a foreign country to give the information pertaining to cybercrime. That itself is also such a huge order. And on top of it, assuming that you got that information and logs, to map this particular cybercrime to a particular cyber actor and going for crystal clear attribution of cybercrime to cyber actor is a very, very challenging task. And assuming you finally do that, there are electronic evidence issues, because electronic evidence that you got from outside India has to be proved in India, in an Indian court of law, as per Indian laws. For example, as per Section 65B of the Indian Evidence Act. So there are huge problems in getting cybercrime evidence from outside India, because there are obstacles in international cooperation. Further, there are huge challenges of public-private partnership in this entire issue of regulating cybercrime. Let me give an example. Recently, a municipal corporation in a small area in India suddenly realized that its systems had been targeted by a ransomware attack. And ransomware is now the most prevalent of all cyber crimes, because every 11 seconds, one legal entity anywhere in the world becomes a victim of a ransomware attack. So what happens in a ransomware attack? Your system gets a malicious code. And that malicious code is of such a nature that you quickly realize that it comes and puts a green lock or a blue lock on your entire data. You can't access your data. It says, we have locked your access to your data and we've encrypted your data. If you want your access to your data back, please give us X amount of monies and bitcoins, and then we will give you access back. This is effectively asking for ransom for having access back to data that's legitimately yours. Now, the FBI, the CBI, they all advocate that don't give a single penny in ransomware. Why? Because the moment you give ransom in a ransomware attack, you're doing two things that's fundamentally going to hurt you. Number one, you are effectively giving a kind of a signal to the cyber criminal that here is a party who has got the money bags or the monies to give ransom, and therefore it's a fertile target. And number two, now that you've given your ransom money to the cyber criminals, there's always going to be a second ransomware attack, because these guys know that you have given the money once, you will give them the money second time over as well. And that, I think, begins to start creating far, far more troubles. So most of the time we find that ransomware attacks are not able to be effectively investigated. Let's take the case of the US colonial pipeline. In this particular case, we found that the US colonial pipelines were attacked by a massive ransomware attack, and all the data was locked. Now, typically, they asked a ransom worth millions of dollars. The company decided to pay millions of dollars and get access back to the data. They were lucky. They paid and they got the access back. But we've also seen cases where you pay the money and you do not get access back. And you also have seen cases where municipalities in the US have chosen not to pay the said ransomware demand and have landed up actually spending double the amount of money in recreating or restoring the data from other sources. So either way, ransomware attack means next 4 months of your operations are impacted, because it's going to take time for you to come back, restore with a backup, try to contain the ransomware attack, then try to find up and come up with more elaborate cybercrime strategy or cybersecurity strategies to secure your particular data or stuff like that. Today's cybercrimes and cybersecurity are intrinsically connected with each other. I call them twin sisters. Why? Because today, for a cybercrime to happen, there has to be breach of a cybersecurity somewhere. Or similarly, for any cyber criminal activity to happen, somewhere down the line, cybersecurity is prejudicially impacted. No wonder the quantum of cybercrimes, the quantum of cybersecurity breaches globally is continuing to grow and will keep on growing. And we have to keep on seeing how this is exercise, which is happening on a regular, frequent basis. There's no denying the fact that cybersecurity is the need of the hour. The time has come where we now need to start inculcating cybersecurity as a way of life. You cannot say that, look, I will do whatever I want to do on my network, on my devices, and that the government will be responsible for my cybersecurity. Sorry. You alone have to be responsible for your cybersecurity. Further, you have to quickly realize that cybersecurity is like a big chain, and we are all links in that big chain. The chain is as strong as the weakest link, and it's our responsibility to ensure that we do not become the weakest link in the cybersecurity chain. Further, we've also begun to see a lot of cybercrimes targeting or in the manifestation of fake news. Now, there's so much of fake news during the pandemic times. No wonder COVID-19 is not just an era of pandemic, it's also an era of cyber pandemic and an infodemic, where all kinds of fake news are getting generated and transmitted. And we are all becoming active parties in this criminal process. You get some urgent message on your WhatsApp, and you suddenly, without even testing the authenticity or veracity of the same, want to go ahead and share it with all your followers, all your friends, without realizing that you could potentially be a pawn in the game of further disseminating of fake news. But that's now the new ground reality. And most of the people are not even aware as to how fake news could have a huge problem. In India, there's a huge problem. Why? Because we don't have a law on fighting fake news. Unlike countries like Singapore, like Malaysia and France, who have got dedicated laws on fake news, India still does not have a dedicated law on fake news, though now under the Information Technology Rules 2021, which have come into effect from 25th of February 21, there is now a responsibility that's been put and straddled on intermediaries that they have to take steps that fake information does not tend to get disseminated on their platforms. How about artificial intelligence and cybercrime? Now, that's not a very likely combination that you could hear much, but the reality is that there's immense amount of work being done in artificial intelligence. And this work is such that now artificial intelligence is both becoming a friend and a foe. Artificial intelligence is being used for committing cybercrimes. Artificial intelligence is also being used for purposes of regulating cybercrimes. You go to the darknet and you find a couple of websites advertising their cybercrime as a service model using artificial intelligence as a premium USP. So they will charge you a bit extra because they are helping you to do your cybercrime dirty work using AI, and therefore they are a bit more expensive. But that's now the new trend of the world that we are working on. Therefore, I think we'll have to start looking at mechanisms of how AI is going to go ahead and increasingly enhance the further ramification of cybercrime. And yet at the same time, law enforcement agencies are increasingly going to go ahead and use artificial intelligence for fighting cybercrimes and cybercriminals. Further now, a lot of new cybercrimes have started emerging on blockchains. This is a technology on which Bitcoin is based and other crypto assets and currencies are based. And now we are beginning to see so many cybercrimes where crypto coins are being stolen from exchanges. And once money gone, that's money gone forever. You don't tend to get it back. So how do you investigate a crypto cyber crime? What kind of mechanisms do you have to put in place for ensuring a successful investigation? Those are big issues that work needs to be currently done. But the three fundamental stages for a cybercrime life cycle circle is detection, investigation, and prosecution of cybercrimes. In India, there's so much of now noise happening. Should we control? Should we regulate cryptocurrencies? The government is coming up at the time when we talk with a new cryptocurrency bill or a crypto assets bill. Earlier, the government was saying, let's ban crypto assets and currencies. Nowadays, reports are suggesting that they're not looking at banning, they're looking at more prudent approaches of trying to regulate the use of crypto for cryptocurrencies, and they want to see them as crypto assets. Further, we also began to see a lot of cyber crimes being done using Internet of Things. Now you'll say, what is Internet of Things? Internet of Things is basically when devices get connected to the Internet as compared to just mobiles or computers. So the moment your smart TV or your smart refrigerator gets connected to the Internet, that's your Internet of Things. But there's a huge problem. The problem is that there is no cybersecurity on the Internet of Things. There are no internationally accepted norms on cybersecurity on Internet of Things. So therefore, doing a cybercrime is child's play on Internet of Things. So we are all familiar with these Alexas and Echos of the world. We see this advertisement on television where somebody is talking to Alexa or Echo to play a particular music or to give information about the weather and stuff like that. It looks so nice. Little do you realize that these devices are constantly recording you. And this data is then constantly going outside India to servers that are located in the US. So they not only are stripping you out of your privacy, but more significantly are also having a huge impact upon further increasing cyber crimes and cybersecurity breaches globally. There's a recent case that took place. Today, a lot of Indians have started buying these Echos and Alexas and putting them in their drawing rooms. A number of Indians are putting them in their bedrooms, little realizing that these devices are constantly hearing. So we had this very bizarre case sometime back where a couple had kept one of these IoT devices in their bedroom. And then the couple was having a very nasty argument with each other. And after which, both of them decided to be quiet and sleep on two separate beds. And then the wife got up and she was in a fit rage. She went ahead and attacked the private parts of the husband. And while she was doing it, she was constantly saying, you did this to me, you did this to me, so I'm doing this to you. Now, this was happening in closed doors. But little did the wife not realize that there was this IoT device. That IoT device was also recording whatever she was saying when she was doing the ghastly act. And lo and behold, that becomes now evidence in a cybercrime matter to show the guilt. So it's a physical world crime where she's gone ahead and attacked the private part of her husband. There's no cybercrime there. But because the IoT device was listening everything and recorded all her sayings in a fit of rage when she was attacking her husband, that becomes electronic evidence. And that, to a large extent, could also be qualifying to be some bit of cybercrime as well. So it's a very interesting world in which we live and new manifestations that are coming up. Facial recognitions are now bringing across new challenges because more and more institutions are now using facial recognition. And you quickly realize that facial recognition is bringing forward its own sets of legal policy and regulatory issues. So where does your facial recognition data get stored? Who all has got access to the same? And what happens if your facial recognition data, which is being stored by the service provider, that tends to get hacked, stolen, and then ultimately sold on to the darknet? Now, those are phenomenal things that are going to further increase the parameters, the foundation, and the ultimate impact of cybercrimes. But I think if you want to go to your utopian place in cybercrimes, then darknet is that utopian place. Darknet is that deep underbelly of the internet where you cannot go using a search engine. You have to go using a particular browser known as the onion router browser. Once you go inside the darknet, you are completely anonymous. And once you are anonymous, you can do anything. No wonder cybercrime as an economy is thriving on the darknet. and all kinds of cybercrime as a service options are available for you. Once you go on the darknet, of course, you have to pay through a cryptocurrency like Bitcoin so that the traceability elements can be minimized and this dark underworld economy can continue to keep on flourishing. But on top of it, we are now finding a new challenge, a new paradigm awaiting us. This is called the metaverse. It's a new version of the internet that's coming in. Already Facebook as a company has chosen to change its name to Meta and has committed billions of dollars for the metaverse. Other companies or other institutions are also working on the metaverse. And tomorrow, metaverse is a place where you and I are going to be spending 8 to 10 to 15 hours a day. And we'll be leaving behind a lot of our digital dust, our digital footprints there. So cybercrime is going to get very, very predominant and very, very expensively clear and prevalent onto the metaverse. And we have to be prepared for the same. One of the biggest challenges in a cybercrime investigation pertains to attribution of the cybercrime to a particular cyber actor. Now, once your system gets hacked, you can only know that it's got hacked. You don't know who has hacked it. So for that, you'll have to investigate. You'll have to find out the logs. And on the basis of the logs, you will then proceed forward and try to identify from which internet protocol address did the hacking attack come from. In case if the hacker has been very tech savvy, he or she would have gone ahead and used a virtual private network, and therefore they would have further gone ahead and obliterated all their footprints. Therefore, trying to identify the real identity of the hacker becomes a humongous challenge. And there are no golden principles in this regard. There are no golden guarantees. In some cases, we are able to get attribution of a particular cybercrime to a particular cyber actor. In a number of times, we are not able to get any kind of such attribution in cybercrime investigation matters. Another big challenge in cybercrime investigations deals with internet jurisdiction. Actually, internet has made geography history, and it's created this boundaryless medium known as cyberspace. In this boundaryless medium, we quickly realize that a person can be sitting in Antarctica and through the internet going ahead and hacking or targeting a particular system or particular person located in Australia because national boundaries have ceased to have any significance. So there's a huge problem. So in this entire context, if a cybercrime is being originated from another country, trying to get the identity of the person, trying to get the relevant incriminating electronic evidence from the place where it actually happened to your own country, and then trying to get it proved and accepted in your courts, in your country, is such a huge, tall challenge. And that's the reason why cybercrime convictions are at a very, very low space, very low edge globally. India has less than 1% cybercrime conviction rate. Further, there are immense number of challenges in the entire processes of detection, investigation, and prosecution of cybercrimes. Problem is the anonymity of the internet has created a huge problem because this anonymity of the internet has effectively promised you that, look, your identity can be hidden. And cyber criminals are misusing this anonymity element to the hilt in going forward and specifically targeting people with their own kinds of cyber criminal activities. So once you're anonymous, what do? You would want to do those things that you cannot do in your physical world. For example, you would go ahead and potentially want to do all those things that you don't want other people to know that you've done. And therefore, this entire issue of anonymity has started coming up and encouraging immense number of cyber criminal aspects as we go forward. And cyber criminals can also use anonymity and anonymity networks to encrypt or to block access. They could block access to traffic, hide internet protocol addresses, or can do a variety of activities. So in a nutshell, using this anonymity umbrella, the cyber criminals can effectively go ahead and, shall I say, try to wipe their digital dust so that they cannot potentially be caught. The problem is globally and nationally, there's lack of harmonious cybercrime laws. Internationally, there's no one international law on cybercrime, though there is a Budapest Convention on Cybercrime of the Council of Europe. But it's still the world's only example of a successful working treaty on cybercrime. This particular cybercrime convention has been signed by 1/3 of the world's nations, but 2/3 of the world's nations have not yet been signing the Budapest Convention. So countries are saying, okay, let me come up with my own national cyber crime laws. And different countries have sought to regulate cybercrime in their national laws, either through appropriate legal provisions under the cyber legal frameworks or coming up with dedicated cybercrime laws. So a number of countries have put cybercrime provisions as part of their cyber laws. These also include countries like India. And then you have countries specifically who have come up with laws on cybercrime like Kenya. So both these models are there, but because there's lack of any harmonized national cyber legal frameworks, there's lack of any international standardization of evidentiary requirements, both in terms of admissibility in a court of law and in terms of international state responsibility. Because of lack of mutual legal assistance on cybercrime matters, and because of lack of timely collection, preservation, and sharing of digital evidence, these are immense problems and obstacles which are waiting for law enforcement agencies as they go forward. Other obstacles of cybercrime investigations include the limited abilities of law enforcement agencies to conduct various cybercrimes investigations. And most of the time we find that the law enforcement agencies are not even clued enough with the latest technological tools, cyber forensic methodologies for the purposes of specifically targeting cybercrimes. Further, during COVID-19, we've also seen that some countries have come up with dedicated cybercrime laws. There are other countries who have enhanced the cyber capacity building of their law enforcement agencies. Actually speaking, with countries realizing that now cybercrime is growing at such a phenomenal pace, they have no choice but to invest in capacity building as far as cybercrime investigations is concerned. Also, we face a lot of technical challenges in cybercrime investigations. For example, numerous digital devices have proprietary operating systems and software that require the use of specialized tools to detect, identify, and preserve the relevant evidence. And these tools are very, very expensive. A lot of times, smaller countries are not even able to afford using these tools. So the problem is when a cybercrime investigation begins, you have to pick up the entire evidence that's available. It could be in the form of equipment, it could be in the form of computers or mobiles, and then you have to conduct your detailed forensic analysis. A lot of times, the police is casual, is careless, and land up opening up the original device. That itself tends to put a lot of questions of suspicion on the role of the police, and therefore, such kind of evidence is often not very much considered reliable by courts of law. In India, we have to quickly realize that we have one mother legislation, being the Indian Information Technology Act 2000. This is India's mother cyber law. In fact, when the parliament passed this law 21 years back, no one, not even the parliamentarians, had any idea of what law they were passing. Over a period of time, the Indian cyber law, being the Information Technology Act 2000, has evolved as one of the three most significant pieces of legislation in Indian history. The other two being the Constitution of India and the Indian Penal Code. Why? Because anything to do with the electronic format is covered under the Indian cyber law. So if you use computers, computer systems, computer networks, computer resources, communication devices, as also data and information in the electronic form, you are specifically covered under the ambit of the cyber law. So this cyber law has also got a specific chapter on cyber crimes. This is chapter Roman 11. So, of course, there are provisions for seeking damages by way of compensation on certain grounds under Section 43 of the IT Act. Further, a variety of activities have been defined as cyber crimes under chapter Roman 11. So, for example, under Section 65, when you tamper with computer source records and documents, it effectively becomes a cyber crime, punishable with 3 years imprisonment, 5 lakh rupees fine. So if you do a variety of cyber or computer-related offenses, they become specific offenses under Section 66, read with Section 43I of the IT Act. So, see, any activity that you do on a computer or on a mobile, which has the effect of diminishing the value or utility of information residing in the said computer resource, or which affects the same injuriously by any means, that invariably is brought within the ambit of criminal penalty. So the IT Act in the year 2000 was just a small piece of legislation. We had only covered some cyber crimes under the said law. But with the Mumbai attacks coming in 2008, you quickly realize that within a period of 1 month, the Parliament of India had amended the Indian Information Technology Act 2000 by virtue of the Information Technology Amendment Act 2008. And these carried out some very vast amendments in the IT Act. One of the key elements of these new amendments were that a number of new cyber crimes were added under the Indian cyber law. Yet another contribution of the IT Act amendments was that barring a few cyber crimes, almost all cyber crimes were made as bailable offenses. And that, I think, has been a biggest historical mistake of the Information Technology Amendment Act 2008. Because once you make almost all cyber crimes as bailable offenses, then what happens? Then people are entitled to bail as a matter of right. And once they have this feeling that they're entitled to bail as a matter of right, they get the bail. And the first thing they do thereafter is to go ahead and delete the relevant incriminating electronic evidence that would go ahead and incriminate them. And once the original electronic evidence is destroyed, there's actually nothing that can be done in terms of convicting you. No wonder India has seen some massive drought of cybercrime convictions ever since the 2008 amendments came up. But the good things of these amendments were that the coverage of cybercrime was massively increased under the IT Act. Under Section 66B, if you are dishonestly receiving any stolen computer resource or a communication device, that becomes a cybercrime punishable with 3 years imprisonment and fine. You engage in identity theft, and that's a separate cybercrime under Section 66C of the Information Technology Act 2000. You cheat by impersonation by using a computer resource, and that becomes a separate cybercrime punishable under Section 66D of the amended Information Technology Act 2000. Further, 66E says that if you violate the privacy of a particular person without that particular person's consent or knowledge, under circumstances where the privacy is indeed invaded or infringed upon, that becomes a separate cybercrime. Further, cyber terrorism has also been declared to be a massive cybercrime, punishable with life imprisonment and fine. A lot of people ask me, is watching pornography illegal in India? I say no. There's not a single law passed by Parliament in the country which makes watching of pornography an offense. The law does not mind if you watch adult content, but they want you to watch it in private spaces, at homes, in closed doors. But if you start watching things in the open public, then that becomes an offense. So the law is not really concerned about viewing of pornography. The law is more concerned about publishing or transmission or causing of to be published or transmitted obscene electronic information. That's what is more important. So the law does not use the word pornographic content. The law also does not use the word obscene content. Instead, Section 67 of the Information Technology Act 2000 says that when you publish material in the electronic form, which is lascivious, or which appeals to the prurient interests, or the effect of which is such as to tend to deprave and corrupt the minds of those who, having regard to the relevant circumstances, are likely to see, read, or hear the same. That's what's an offense, right? So you have to be just clear that Section 67 makes this an offense, 3 years imprisonment, 5 lakh rupees fine. But the moment you start publishing or transmitting electronic content that has got explicit sexual content, for example, explicit sexual intercourse or other content, then that's a more serious offense, punishable under Section 67A of the IT Act, 5 years imprisonment, 10 lakh rupees fine. The Indian IT Act has also been added so as to specifically cover child pornography as a specific offense under Section 67B of the IT Act. Again, punishable seriously with imprisonment and fine, non-bailable offenses, 5 years imprisonment, 10 lakh rupees fine. So much so that the law says even if you browse child pornography, that also becomes an offense. And your intention that you wanted to or did not want to browse is of no consequence. The moment you browse child pornography, that becomes an offense. Similarly, there are cybercrimes concerning misrepresentation, concerning breach of confidentiality and privacy, concerning disclosure of information and breach of a lawful contract, concerning publishing digital signatures or electronic signatures false in certain particulars, or publication of the same for fraudulent purposes. So in India, we've seen a number of cybercrime convictions happening. I was the counsel for the complainant in India's first cybercrime conviction in the case of CBI versus Arif Azim. This was a case of a call center employee who had actually gone ahead and misused the credit card of an American girl and had ordered for his own self some Sony products on a Sony website. We were able to target him, get him, and he was convicted not for any cybercrime, but for cheating under Section 420 of the Indian Penal Code. At that time, 2003, we thought that's fantastic. That's going to open up new doors of more convictions. Some years saw some convictions, but after 2008, India has been seeing a massive famine of cybercrime convictions because the IT amendments in the year 2008 made almost all cybercrimes, barring a few ones, as bailable offenses. And once you are entitled to bail, you go ahead and destroy evidence, and thereafter you cannot get any successful chances of getting convictions in such matters. So these are some cases where cybercrimes have happened in India. There was a Pune Citibank Memphis call center fraud case. Then there was a bank NSP case. There were a number of cases pertaining to Bazi.com. Then you had Suhas Katti case, and then Dr. L. Prakash case. So in cybercrime investigations, data repositories play a very important role. The Googles, the Facebooks, the Instagrams of the world are having access to all your logs, all your activities. And these logs and activities tell you that, look, they have become very powerful. No wonder law enforcement agencies are increasingly now relying upon the data provided by these intermediaries. And now under the IT rules 2021, more responsibilities have been given. They have been mandated to comply and cooperate with all the requests of law enforcement agencies for such electronic logs as the law enforcement agency may ask. Further, the IT rules have also said that, look, if we are using end-to-end encryption, then please hand over, let us know the real identity of the person who has initiated a particular or incriminating electronic message or record. Why? Because that particular identity details could be very useful for the law enforcement agencies to go ahead and target the concerned cyber criminals. These are new IT rules 2021, which you must know. They are very called, a very long name, the Information Technology Intermediary Guidelines and Digital Media Ethics Rules 2021. So all kinds of cybercrimes are happening on a regular basis in India, whether we find DDoS attacks, botnets, identity theft, cyber stalking, social engineering, then potentially unwarranted programs, phishing, prohibited/illegal content, pornography, online scams, exploit kits, hacking, virus dissemination, webjacking, financial frauds, salami slicing attack, software piracy, ransomware, and online defamation. Now, when will this famine of cybercrime convictions in the country come to an end? That will only come to an end once India decides to amend its IT Act again and make a majority of cybercrimes as non-bailable offences, where the cyber criminal is not entitled to bail as a matter of right. Further, in electronic crimes or cyber crimes, electronic evidence issues are of crucial necessity. Assuming that you have got all the evidence, assuming that you've cracked the cybercrime case, the fact is you still would be required to go ahead and prove the said electronic evidence in a court of law. And that being so, it therefore will be very, very essential that the electronic evidence will assume far, far more relevance and significance with each passing day in cybercrime investigations, detections, and prosecutions. Well, a couple of years back, we did a survey. We found out 1 out of every 5 cases in India would have a cyber or an electronic evidence component. But we were wrong. By the time COVID-19 came, this figure has jumped up. Now, almost 3.5 out of every 5 cases that take place in India have got an electronic evidence component. And increasingly, this kind of electronic evidence is required to be presented in courts of law. Further, today, video conferencing has become the central lifeline of people. And therefore, video conferencing is also being used extensively for committing cybercrime, for making people victims of cybercrime. That, of course, is bringing up huge number of legal, policy, and regulatory issues, which will have a direct impact upon detection and investigation of cybercrimes. But I think in India, you have to quickly realize that the law pertaining to electronic evidence has been constantly evolving. The law was unsettled. Different courts were taking different stands, different interpretations. Actually, the Information Technology Act 2000, in the year 2000, had also, by virtue of one schedule, amended the Indian Evidence Act. And by virtue of these amendments, had introduced a particular section, being Section 65A and 65B of the Indian Evidence Act. These particular sections deal with the admissibility of electronic records. These sections became very, very important, but because they were very huge, very vast in their scope and ambit, different courts started interpreting them in different manner. Consequently, finally the matter came up before the Supreme Court, and in the landmark judgment of Anwar PV versus PK Bashir, the Supreme Court clarified the law pertaining to electronic evidence. And they said, look, this will now henceforth be the law pertaining to electronic evidence. Let's see what Supreme Court said in Anwar versus Bashir. Supreme Court said that Section 65B of the Evidence Act is a distinctive code in its own self. And that if you have to prove an electronic evidence, you will have to give a certificate under Section 65B of the Evidence Act, specifically certifying that the computer output has been generated from a computer and that the original electronic record has not been tampered, altered, or manipulated in any manner whatsoever. So Anwar versus PK Bashir made the certificate under Section 65B of the Evidence Act as mandatory. Then we started seeing some more judgments of the Supreme Court coming in. We had Shafi Muhammad versus State of Himachal Pradesh, where the Supreme Court said, well, 65B could require a relook, and that Anwar versus Bashir does not mean that you require a 65B certificate all the times. So they sought to create certain carving of exceptions. And as we found different benches of the Supreme Court coming at with new nuanced interpretations of Section 65B of the Evidence Act, the Supreme Court felt that it's time that this entire conflict might be put to rest. So the matter was referred to a constitution bench, and in the landmark judgment in July 2020 of the case of Arjun Pandit Rao Khotkar versus Kailash Ghorantyal, the Supreme Court has reiterated and clarified the law pertaining to electronic evidence. They've reiterated the law that's been held in Anwar versus PK Bashir, and they've held that being a special law, the general law under Section 63 and 65 has to yield. Section 65B of the Indian Evidence Act being the special provision dealing with admissibility of electronic records, the general law under Section 63 and 65 of the Indian Evidence Act has yet to yield. So if you have to now prove any kind of a computer output, a printout, or a soft copy on a pen drive or a CD-ROM in a court of law in India, then you are required to ensure that the following conditions must be fulfilled. There must be, number one, a certificate, which identifies the electronic record containing the statement. Number two, the certificate must describe the manner in which the said electronic record was produced. Number three, the certificate must furnish the particulars of the device that was involved in the production of this record. That certificate must deal with all the four conditions which are mentioned under Section 65B(2) of the Indian Evidence Act as amended. Next, the certificate must be signed by a person occupying a responsible official position in relation to the operation of the device. This is what was being upheld by the Supreme Court. In Shafi Muhammad, they had actually slightly deviated. They had said, accordingly, we clarify the legal position on the subject of admissibility of electronic evidence, especially the party who's not in possession of a device from which a document is produced. Such party cannot be required to produce certificate under Section 65B(4) of the Evidence Act. That means if you are a person who said, look, I've lost the original device, then this judgment said, then no problem, you are not required to give us 65B. But then this judgment of Shafi Muhammad versus state of Himachal Pradesh has actually now been overruled in the Constitution Bench judgment in the case of Arjun Pandit Rao Khotkar versus Kailash Ghoramtial. Now this is the landmark judgment. It has reiterated the provisions of Anwar PB versus PK Bashir. And therefore, now the law is very, very clear. But only the law is clear. In each case, electronic evidence will still have to be appropriately proved and produced in accordance with the provisions of law, specifically Section 65B of the Evidence Act. So therefore, I believe there's a need for massive capacity building when we are looking at the entire issues in cybercrime investigation, specifically the entire issues concerning the detection, investigation, and prosecution of cybercrimes. Therefore, capacity building is of essential importance. I have been distinctly fortunate and have had the privilege to conduct various training sessions at the National Police Academy in Hyderabad and the National Judicial Academy in Bhopal, apart from various state judicial academies. And these all courses and these particular programs are all ultimately aimed at enhancing capacities amongst law enforcement agencies, as also amongst the particular judiciary and the judicial officers as well. I also had the distinction of having the pleasure of conducting a capacity building program, training program, and sensitization program at the International Court of Justice for the judges of the International Court of Justice and the staff of the International Court of Justice. And I can tell you, there's a need for so much of more capacity building that's happening globally, also at regional levels, apart from national and also state and local levels. Fortunately, now the government of India is very much committed towards fighting cybercrime. They have launched an online Indian portal known on National Cybercrime Reporting Portal. It's available on the website cybercrime.gov.in. So the next time you become a victim of a cybercrime, you can go to this online portal and you could go ahead and register this online cybercrime complaint. 155260 is also the national helpline that's available to you should you want to go ahead. Further, India is still not a member of the Budapest Convention or the Convention on Cybercrime of the Council of Europe. And therefore, India does not have the benefit of having access to expeditious electronic evidence under the Budapest Convention. But having said that, India has got its own concerns because according to India, Budapest Convention is wanting India to make some changes in its laws, which could potentially be having an impact upon the sovereignty, security, and integrity of India. Further, we find that there are a lot of practical difficulties which are faced by law enforcement agencies in obtaining the relevant incriminating evidence from entities outside India. Coming of lockdowns have completely changed the scenario. Lockdowns and the work from home has now become the new normal. And in this work from home, there are a lot of cyber crimes that are happening. A lot of employees in India who are having access to the corporate data of their employers are now beginning to misuse the data, steal the data, sell the data, And we've beginning to start seeing so many of these cases happening in this regard. So much so that cyber attacks against remote access protocols have massively arisen to greater heights during COVID-19. There are more work from home cybercrime matters that have now emerged during the pandemic times. So you can do a number of things once you become a victim of a cybercrime. I've tried to list certain of these illustrations or precautions or steps that you need to be taking in this regard. If you are working in a company, you need to notify that to the company. You also have to look at your softwares. You have to report the matter to law enforcement agencies. You have to disconnect your device from the internet so as to prevent the cyber criminals from accessing your device. You will have to have a good antivirus program to continue to protect and preserve the cyber security of your system. And in case if your sensitive personal data has been leaked or unauthorizedly accessed, you must sensitize and report this to the concerned law enforcement agencies and the concerned data breach notification agencies. Like in India, you have to mandatorily report this to the Indian Nodal Agency on Cyber Security, being the Indian Computer Emergency Response Team. And of course, please, you will have to report the cybercrime. Please don't be under the rigmarole of not reporting a cybercrime and becoming a silent spectator. Actually speaking, all this is telling us that we are entering into a new cyber age. During COVID-19 times, I wrote a book called New Cyber World Order Post-COVID-19. In this book, I wrote down that by the time the nations are successful against the current and subsequent wave of COVID-19 infections, we will enter into a new cyber age where a new cyber world order will await us, where cyber crimes will become the new default and increasing cybersecurity breaches will be our new normal. Therefore, I think we have to now be prepared for a new range of a new world and a new world order that's waiting for us. And cybercrime will be our daily companions. Therefore, in this entire ecosystem, the role of capacity building becomes that of crucial necessity. This capacity building has to be of the law enforcement agencies, of judiciary, and of a variety of other stakeholders, including the present capacity building program that's being undertaken. Well, we've created an online portal known as cyberlawuniversity.com. This is an online education portal where various courses on different aspects of cyber law are made available. We offer various international certification courses on cyber law, cybercrime law, cybersecurity law, artificial intelligence law. We've also tied up with the National Law School at Ranchi by offering an online certificate course on cyber law. And we also have various short courses. And these courses have already been done by more than 26,500 students from 172 countries across the world, speaking 52 distinctive national languages. So clearly, these are telling us that the need for capacity building is massive. And therefore, every digital stakeholder today has to be engaging in some form of capacity building so that they can prevent themselves from becoming victims of cyber crimes. As I come to the conclusion of my thought process, I can clearly tell you that cybercrime is a constantly growing paradigm. It will constantly keep on growing and worsening with each passing day, month, and year. And the growing cybercrimes under COVID-19 times have specifically been the three musketeers of phishing, identity theft, and online financial fraud. There's need ultimately, as we go forward, not only to update your cyber legal frameworks on cyber crimes, but also to provide effective legal frameworks for regulating cybercrime. There's need for creating effective remedies for effective redress to the victims of cybercrime. The law needs to be strengthened. In India, for example, the Indian Information Technology Act 2000 has to be definitely gone ahead and updated so that it can potentially be made more topical and relevant in today's context, in the context of cyber crimes. Most of the cyber crimes under the Indian cyber law today now need to be made as non-bailable offenses. They need to have a semblance of deterrence, very essential as an integral part of India's fight against cybercrime. The struggle against cybercrime is a constantly developing one. So therefore, only effectively detecting, investigating, and prosecuting cybercrimes and having an effective deterrent legal framework against cybercrimes could be the best way going forward for a country like India. Let's all join hands together in fighting the menace of cybercrime as we go forward to face new cyber legal challenges in the coming times. Thank you, ladies and gentlemen. It's been a pleasure talking with you, and I'll be happy to answer any specific questions that anyone may have. Thanks.